Afternoon. Welcome to Broadband Breakfast Live Online. My name is Drew Clark. I'm editor and publisher of Broadband Breakfast, where we believe in better broadband, better lives. We focus on the infrastructure, the applications, and the uses of high capacity broadband. And Section 230 is squarely within the set of issues that have been raised by higher broadband capacity. We have an excellent panel that will be talking about this topic. We've framed it as the changing nature of the debate about social media and Section 230. And the elephant in the room, of course, is all of the attention and criticism that Facebook has received over the last month and change over, revelations about knowledge that the company has had apparently about the effects of social media. And so we're going to speak to, or our panelists will speak to this topic during the course of our discussion here, hour-long discussion, as all of our Broadband Breakfast Live Online events. Let me just say a word or two about this discussion series, Broadband Breakfast Live Online. We've been doing this for a year and a half now, more than a year and a half since the pandemic began. We've been meeting virtually once a week, Wednesday at 12 noon Eastern time. One of our panelists joked that should it be Broadband Breakfast or Broadband Lunch? Well, we started as Broadband Breakfast years ago, and we obviously keep that name. We do have a monthly event on the second Wednesday of each month, including December, where we do Broadband Breakfast for lunch. So you can register and join us for that event on Wednesday, December 8th at Clyde's of Gallery Place. But we're still going to be live streaming it, right? That's part of what we've discovered, is we want to be able to reach all of you who aren't necessarily in Washington, and we're grateful for those of you joining us. We will have some exciting upcoming events. Next week, we're going to be talking about, being thankful for better broadband, including broadband adoption programs. On December 1st, we're going to talk about privacy issues. On December 8th, we're going to be talking in detail about the Infrastructure Investment and Jobs Act, which passed about 12 days ago and was signed by President Biden 2 days ago. So lots and lots to talk about on IIJA. And then we'll talk the next week about public-private partnerships. And again, before we turn squarely to our topic, I do want to thank our sponsors of Broadband Breakfast for making these events possible. We're grateful for Utopia Fiber, Lit Communities, Broadband Now, Broadband.money, Samsung Electronics America, Render Networks, Positron Access, the California Emerging Technology Fund, and Powerhouse Management. Thank you for the support. Each of you are sponsors. Let us open wide the view for each of our panelists. Again, this is a great group. Some have been here before, some haven't, but those who haven't, we've wanted to have on. So thank you for being here. We're going to kind of go in the order that is laid out on the program. I don't 100% know everyone's take on this. Feel free to talk about social media, about Facebook, about Section 230, and how we fix whatever we need to fix. What is the problem and what is the solution? So with that, let's turn first to Scott Mccullough. He's an attorney with the Mccullough Law Firm, has been very involved in these issues for many years. He may or may not speak about the Texas and Florida laws that have been passed on this subject, as I'm sure others will. I believe Shane Tews, the next speaker, will be able to speak to that. She's a non-resident senior fellow at the American Enterprise Institute, and has her own podcast, right? Talk to Shane, I think. Maybe I haven't got that right. What is it, Shane?
Explain to Shane.
Explain to Shane. Explain to Shane. Great name there. Shane will be followed by Alex Fierst, who is the co-founder of Digital Trust and Safety Partnership. And Alex was on our three-part series about Section 230 we did in July of 2020. Following Alex is Rick Lane, CEO of Iggy Ventures. And following Rick will be Matt Gerst, who is the Vice President for Legal and Policy Affairs of the Internet Association. And I'm certain this is a topic of great interest to the Internet Association. So with that, let's turn it over to Scott for up to 5 minutes. Go for it, Scott.
Thank you. Let me do a little bit of house cleaning. First, a disclosure. I've represented the folks who own Powerhouse Management, one of the sponsors here, since like 1995. And many of the historical things that I hope to get into tonight were undertaken on their behalf for one of the companies that they own. So I need to get that disclosure. Second, let me apologize up front by kind of going on offense and naming names, including some of the groups represented on the panel. Please don't take any offense. Y'all are not the only ones guilty of the things I'll talk about. Just to make clear, I rise in defense of the state's rights to protect their citizens and users on the internet against some of the behaviors and actions that are covered by the protections and immunities afforded by Section 230. In particular, I want to talk about Florida and Texas, because both of those states are in litigation right now. The Florida bill is presently before the 11th Circuit. A whole bunch of amicus briefs were filed just the other day, including by the Internet Association, I noticed. I'm going to assume for purposes of this that the panel member here from that group is embracing what's said in that brief. I do want to say, however, that the Texas bill is not the Florida bill. The Florida bill does admittedly have some warts. For example, it compels speech by these platforms. And I think that's a problem. It isolates, in particular, certain categories of speech by politicians and journalists that I think are also problematic. And finally, it entirely carves out the magical kingdom, any enterprise owned by Disney, because they own an entertainment facility in the state. That too is both, of course, driven by politics, but also problematic for many reasons. Now, background. Oh, by the way, the Texas bill doesn't have these words. All right, and I'll get into that. My background. I've been part of the open networks and internet wars since, frankly, before there was a public internet. I was active in this area back before divestiture, back before the 96 Act. I worked, well, along with many others, to implement what was then the prevailing regime at the FCC called the computer inquiry. I know the provenance of the act. I was involved in the modification of final judgment action. I know what the terms mean. I was also involved very much in the so-called net neutrality wars that have yo-yoed back and forth between the FCC and the courts. And I remember very specifically one time when we were in the same group as Google and many of the forebears of the companies that are now the focus of this debate. We tried to tell them, if you go for net neutrality and deem internet access to be deemed a telecommunications service, it will not be long before those concepts reach up the stack and capture you. And that's where we are today. I remember when folks like the Internet Association, I think, asserted that if internet access is a telecommunications service, then that classification should also extend to online service providers, including those under inquiry pursuant to the Section 230 analysis. So I know where the bodies are buried. Our topic today is social media and Section 230. One of the first things that you have to do with Section 230 is understand the whole text of the whole act. You need to pay particular attention to sections A2, B3, D, and E3, because they establish the congressional findings. And while it is true that these platforms receive some measure of immunity, the purpose behind the bill and the act was to protect users, user choice, user freedom. That is best exemplified by the congressional findings and indeed Section E3, which talks about filtering. One of the provisions in there says that any online provider has to offer software by way of a filtering tool that was basically at the time a client software device. It was used locally to filter. And the problem now is that the prevailing arguments against state laws like Texas, and Florida is they ignore this congressional focus on user empowerment and control. The situation is truly that users don't have power or control. The platforms do. And they assert the power to override user choice and desire. Many of the arguments against bills like Texas and Florida very much conflate the purposes behind in the independent operation of C1 and C2. They serve different purposes. They confuse conflict preemption with field preemption, something that the Internet Association directly did in its recently filed brief. They essentially claim that states cannot act at all in this area, even though Section 230E2 expressly says it does not establish field preemption, only conflict preemption. Further, they contend that the state laws transgress when they recognize that platforms are common law common carriers. But to do that, they address only statutory common carrier law, like in the Telecommunications Act. Worse, and again, the Internet Association wrongly contends that Section 230 was put in Title II of the Communications Act because it was part of the Telecommunications Act of 1996. That's not factually correct. It was a separate bill, the Communications Decency Act. The reason it's in Title II, and specifically in Section 230, is that's where the people who do the code put it. And that is clear from the notes to that section, if you just look. The thing that bothers me the most is why they completely mess up why these platforms are not telecommunications carriers. The reason this is so is because the FCC long ago deemed that they would not be treated as telecommunications providers and carriers, even when they may actually meet the test. Let me be straight. The commission has never held that platforms do not meet the common law common carriage test. And that is because many, perhaps not all, clearly do, if you simply set out the test in the DC Circuit's Nargert case. Now, let me emphasize, it's not all of them, some of them.
Scott.
Yes.
Scott, can you just wrap up so we can get to others as well, and you'll be able to come into these discussions here after we get everything set on the table.
Yes, certainly so. We need to understand what the common carrier test is. It's a test that's applied at the front end, whether they hold out to indifferently serve. It's not what rights they reserve in the back end after the customer contract has been formed. So the question becomes whether states can regulate them within the limits of 230, and if so, how much? One thing is clear, a state can impose liability for actions taken not in good faith or not voluntarily undertaken. That's a mixed question of fact and law, and it has both subjective and objective components. So you have to look at each of these bills individually and then apply them to the specific facts, including by reference to the terms and conditions of service by each individual carrier. And so these wide assertions that these bills are just completely preempted are flatly wrong. Thank you.
All right. So there's a very interesting point here about the laws that have been passed, and we've done a little bit of reporting on Broadband Breakfast about the Texas law. Then there's the Florida law, and I can't speak to the differences, but perhaps we can come back and into that a little bit more. But you've definitely staked out some very strong opinions here, Scott, about the ability of states to pass laws like this and not to be preempted. Let's go now to Shane for your thoughts on our topic as a whole.
Thanks, Drew. And Scott, thank you for giving us kind of the legal baseline on that. Oh, you can hear me okay, right?
Yeah.
Right. So I am not a lawyer. I'm a fairly educated commentator who has been listening to this discussion since 1995. I'm always challenged because I feel like a lot of people think that Section 230 is legal aspirin and it solves all problems, and it doesn't. So I had the opportunity to talk to several people that were very smart on this, and I'd really never heard the delineation between C1 and C2. And since I do have a podcast called Explain to Shane, which is just that, I put people on and explain stuff to me. I had Neil Fried on in, I think, September to talk about the difference between C1 and C2, which then brought me the opportunity to actually have the co-sponsor of Section 230, former Congressman and former head of the SEC, Chris Cox, on to give a very good dissemination of not only the original intent of the law and when it was part of the Communications Decency Act, the one section that wasn't struck down. And what he also goes into talking about what is going on in the states. So a little self-promotion there, but I think it's really about hearing Chris Cox talk about it, as well as Neil Fried, who do a great job working through this. So part of the challenge is, and I'm going to steal Rick Lane's line before he gets to say it, is content versus conduct. And I think that's where we have seen a vast difference from the original intent in 1995, 96, where Chris Cox and now Senator Ron Wyden were looking to defend these then nascent platforms from any liability for the fear that they would never get off the ground. And these were really, I used this example yesterday to somebody who was too young to understand the beginning of 95, that it's sort of like Nextdoor. Like if you get on Nextdoor and I make a comment and I'm looking for something and then somebody says something unkind about it, that's not the platform of Nextdoor's fault. So that gives you an idea of the original, idea of it wasn't all that sophisticated of communications, but it needed to be protected. So now we come to where we are with social media. And I'm just going to say my point of view on social media is it's a very nice to have. I enjoy it. I stay very well connected to people because of the multiple platforms that are available, but it's not a utility. It is something that you have options on. And I'm also going to bring up another topic because this somewhat links to where Section 230 is getting heightened again, is the current antitrust / competition bills that are in both House, the Senate. These are companies that you have the opportunity to use. They put very interesting tool sets forward. They have brought a lot of things that happen in society forward, which is discord and disinformation, but they are not the only areas where this is happening. And we need to manage this as a societal challenge, not just a Facebook challenge or, really Facebook, because Instagram doesn't have that on there. So I just want to highlight that you don't have to use a particular company's products. You have choices, and Section 230 is just part of a very large debate about what's going on in this area.
Wonderful. Well, thank you so much for those comments, Shane, and kind of giving us that perspective that there's a lot to deal with on a broad level and not just a particular entity. All right, so continuing our range through the group, let's turn now to Alex. What is your observations on this question that we're discussing here?
Thanks for having me. So I come at this from a sort of a pragmatic practitioner's place. I moderated content for many years, leading trust and safety at Medium, which is a blogging platform that some of you may have used. Spent more than 4 years trying to do this work of writing rule sets that could be enforced fairly and with consistency and with legitimacy, and trying to foster transparency and due process and other important things as part of that process. So I just have like a couple of pragmatic comments. One of them is that for folks who are dealing with this issue conceptually and theoretically, which I think is valuable, I sort of recommend that you try to do some moderating, because I think it really helps drive home what the actual activity is. And I would say, if you don't like Facebook, start a Slack group, but start a Facebook group. You can use any number of platforms out there to gather your 50 closest friends or professional colleagues, set some standards for conduct, and see how you do. And I think what you might learn is that pretty soon everybody's angry at you. And I think that is maybe one of the universal rules of trying to run any kind of group or platform, which is that it may seem super clear to you what speech is good and what speech is bad, but it turns out there's going to be 51 people in the room. There's going to be 51 different opinions on those things. And because we are subjective and we are trapped in our own skin and sometimes universalize our own views, this is sometimes called the moderator's dilemma, which is that you have a platform, you have a company, and you do your best, but some people may say, this is obviously bad, take this down. And another person will say, this is obviously good and important, leave this up. And one of them is going to be angry at you, and one of them may actually sue you. And that's why CDA 230 exists in the first place, to try to extricate you from being sued by one or both of these parties, because you might say, well, they're choosing to say these things, and why are you guys mad at me? But to me, that's like the originary concept of CDA 230 was to extricate the platform from this so-called moderator's dilemma. And then there's a million things we've learned since then that are germane, such as algorithmic selection and amplification sort of changes the terrain of this, and you're in an artificially constructed environment with different kinds of incentives and different kinds of interventions where you might say that a platform has ethical or moral or other forms of responsibility to be held accountable for the design decisions that they've made. And so something as simple as immunity is not appropriate when there is activity taking place. And all these things I think should be taken into account. But I think the core moderator's dilemma really is a structural issue that comes from a fundamental thing, which is human speech. Sort of if hell is other people, I think content moderation is other people's expression. And I think you'll sort of, as you concretely try to moderate, I think you will learn the difficulty. And I'll just say one or two more things and then shut up. The other one is that I would say solutionism, I think, is not helpful here, because I don't know if this is a problem to be solved, right? Human expression to me is not a problem to be solved. It is a condition to be managed, right? And so you might even say, like, is crime a problem to be solved? Now, you may try to get it to as close to zero as possible, but what you're really dealing with is mitigations and strategies for reducing risk, strategies for reducing harm, and allowing for as much speech as possible to exist while reducing harm as much as possible. And this is a dynamic, constantly transforming problem. You don't quote unquote solve it, you mitigate it. I sometimes say to folks, like, it's like having diabetes. You have diabetes of human expression. There's a lot of human expression every day. There's not enough insulin in the expression system to regulate it. You're just going to have to adopt some management strategies, and you're going to have good days and bad days. And the bad days may be very bad, but there's no doubt that there's mitigation strategies, and that platforms can and should adopt these. Finally, I would say that there's part of the Digital Trust and Safety Partnership we're a voluntary industry-led group adopting best practices by platforms that have invested in and done this work and are trying to do it better, trying to standardize some of the practices, trying to create objective assessment instruments so that there can be sort of objective reports published to the public about how the work's being done, who's doing it, and all the different standards that a company can be held to in public-facing reports by assessors who are not from inside the company. So we're trying to, I think, shore up some of the sort of transparency and also trust building where there's maybe a deficit now by allowing companies to be clear about what they're doing and admit where they can do better. And so maybe before I end, I would say that I think this is like a very promising area. It's certainly not perfect, because the fact is that the number of speech adjudications that have to happen in daily life now has multiplied by a tremendous amount. You can think about 40 years ago or 100 years ago, the demand for somebody to adjudicate some sort of speech dispute was relatively tiny, but it now happens millions of times a day because of the internet and other things, that people seem to be asking a third party, and maybe platforms are not the right one. Certainly, I think maybe government is probably not the right adjudicator, but to adjudicate some sort of speech dispute and come up with an outcome. And that's sort of expensive and will inevitably lead to these disagreements, which is why I sort of say, don't look for solutions to this. What you have is like an incredible multiplication of the amount of adjudications that are happening around speech and expression. And I very much second Shane's point that this is sort of hydraulically tied to other aspects of society. It may be a visible manifestation that this happens in technology, but the fact is it is tied to education and politicization of other things and all the manifold issues that a society is struggling with that bubble up through expression on platforms. And so while there may be a technological manifestation that is irksome right now, the quote unquote solutions, which I would say are more like mitigations and strategies, are going to be tied to a whole bunch of things that have potentially very little to do with technology and more to do with education and other forms of media and a lot of the other ways that we grapple with each other and that we express ourselves online and elsewhere. So I'll leave off for now, but thanks again for letting me participate.
Wonderful. Let's go right into Rick Lane.
Thanks, Drew, for having me. It's a pleasure to be on such an incredible panel. First of all, I am the CEO of Iggy Ventures, but in this capacity, I'm not representing anybody. I actually volunteer my time for and to help anti-sex trafficking groups and anti-child safety groups, advising them on technology policy and kind of how to either enact or stop legislation from going forward. But that's a complete volunteer basis. So for this is a volunteer effort, but it's a policy of interest to me, just because I think it can help others make the internet much safer. About 5 years ago, I had a conversation with my good friend Steve Del Bianco at the State of the Net, and said to him, if the platforms continue to hide behind Section 230, there is a real risk that Section 230 will be repealed, and that will be a big problem. So I suggested to him at the time, why don't we work together and try to figure out how we can modify it in a way that keeps the good without and gets rid of the bad. The first effort that I engaged in my volunteer effort was the FOSTA-SESTA legislation. People said we would never be able to beat back Silicon Valley. At the end of the day, even the Internet Association endorsed the legislation. Now we're looking at what can we do to not go after the awful but lawful content. I think that's where the debate gets bogged down. I think that's probably why we have a problem with the Florida and the Texas legislation on the First Amendment grounds. We may not like the speech. We may want people to do more for the speech, but the reality is there's a First Amendment in this country, and that's a great thing. But what, as Shane said, I look at trying to figure out what is the conduct that we can do. Should these platforms be shielded from conduct? Should they be allowed to be shielded when somebody is selling illegal drugs on their site? Should it be a civil, have the civil ability to go after websites if you're harmed by the design of their product, like you're able to if I design a car? You know, Tesla, because they're a tech company and a car company, it doesn't get rid of all their liability if they have a malfunction in the software or in the car itself. So these are the questions, and should everything be stopped at the courthouse steps? And that was the really the cornerstone of the FOSTA-SESTA debate that I thought was really important. I hear a lot, well, if platforms engage in criminal activity, that's already covered. Well, yes and no. It's covered at the federal level, but it's not covered at the state and local level if a platform engaged in illegal activity. And they're also blocked from civil cases. And even the Department of Justice has, in their report from the last administration, said that could even block the federal government from bringing civil action. So there's a lot of unknowns. So we're trying to do is try to clarify those, to say you shouldn't be stopped at the courthouse steps. And you just take a look at Backpage. Backpage is always used, well, they shut it down before FOSTA-SESTA was enacted, and that is true. But it took a Senate investigation to find out all the horrible things that was happening on Backpage. The state AGs were trying to bring those cases, and they were blocked at the courthouse steps. Civil litigants whose daughters were murdered and sold on Backpage try to bring civil complaints, and they were blocked. And FOSTA-SESTA now says that those cases can at least move forward, that the platforms can still win if they're not engaged in these activities. And it's just a matter of, you know, we just didn't know is not the right answer. And I'll end on this point. You know, back at the TPI event in 2020, I got a question asked to the former CEO of TikTok. And the question that the moderator asked was very simple. Have you ever been told that there are illegal drug sales happening on TikTok? And they both scoffed at that question. Like, we've never heard that. That's never been brought to my attention. You know, that's just, you know, not true. Yet everybody knew it was true. I wrote a piece before the TPI on the drug sales happening on TikTok. All the drug dealers seemed to know because they were utilizing TikTok. So why was it that the CEO of a platform that is targeting young people, 13 to 17-year-olds, does not know that its site has been being used by bad people to sell drugs? Now, should TikTok be held accountable for that? That's a separate question. But how does he not know? And the reason he doesn't know, because he doesn't have to know because of Section 230. There's no legal risk at this point. And so those are the types of problems that we're trying to solve. Not the lawful but awful content problem that's out there and the harm that that does cause, but the conduct and the profiting off of illegal activities that are being protected by a very overbroad view and legal interpretation of Section 230.
Thank you for keeping within the time limit, Rick. And let's go now to Matt Gertz to tell us about some of the many reports. We've got links to them that Internet Association has put out on Section 230, the state of Section 230, as well as your thoughts on some of these questions about Texas and Florida law. So Matt, floor is yours.
Sure. Well, hi, everybody. I'm Matt Gerst. I'm the Vice President of Law and Policy at Internet Association. And just want to say thank you for inviting us to participate in this important discussion, and also to appreciate all of the perspectives and longevity on these issues of the other panelists. I actually just joined the Internet Association a few months ago from a prior role working on wireless issues. But I've learned a lot over the last few months working on some of these issues, and I'd like to share some perspectives on it. But I think what I hope you hear from my remarks today is that we're open to discussions on a lot of these issues and want to be part of the solution. So at Internet Association, our mission is to foster innovation, promote economic growth, and empower people through the free and open internet. IA represents over 40 of the world's leading internet companies, and we say we represent A to Z on the internet, everybody from Airbnb to ZipRecruiter. And every day, as Alex noted, their users are posting billions of content online, and we post pictures and videos, and we write ideas that are informative and educational and inspiring and many times funny. But many people post and see content that can be disturbing and unwanted. And today's world has shown that both the tangible benefits of online services and the critical role that the platforms play in ensuring that their services are not undermined and misused in ways that threaten individual lives or the public good. In particular, social media has allowed people across the globe to stay connected during this ongoing pandemic, and it helped facilitate the organization of unprecedented protests for social justice last year, facilitate important COVID-19 research, not just in the US, but also worldwide. However, a number of bad actors do continue to misuse our platforms to mislead, harass, exploit, or engage in other unwanted conduct. IA member companies recognize that in order to realize the full benefits of the internet, it is critical that they take action to prevent and respond to harmful online activities. This is essential to building and maintaining both user and public trust. So let me address a few points that were, a couple of which were brought up, and reiterate some of which what Shane and Alex also pointed out first, which is content moderation decisions are complex and challenging, but they're also necessary. And IA's member companies' terms of service generally do not permit content that is illegal, and each platform establishes community guidelines about harmful content. If our companies find or receive a report of content that violates their policies, they will act. In many cases, illegal and harmful content is blocked before it's ever posted or quickly taken down. Companies are using automated algorithms and artificial intelligence and machine learning, as well as human reviewers and other stakeholders, to screen or remove posts, images, videos, or other content that violates law or community standards. Now, often we hear some people say there isn't enough moderation happening. At the same time, we hear others saying there's too much. So given the enormous volume of content online, and oftentimes, as Alex noted, nuanced and subjective decisions about whether content violates community standards, IA's member companies are working hard to strike the right balance between facilitating speech and mitigating harm. Now, second, I want to note that it's the First Amendment that enables online companies the flexibility to facilitate speech and moderate speech on their platforms. Section 230 just provides them with the certainty that those actions won't face litigation or regulatory burdens, which would discourage innovation or investment, continue making the internet a better, safer experience for everybody. Now, Section 230 doesn't just protect large social media platforms whose actions are getting the most attention. IA has found that Section 230 has often been used to protect small and local businesses and organizations and innovative internet companies. Those are the entities that would be hardest hit by any modifications to those liability protections as the way to address concerns about content moderation. Section 230 also doesn't grant blanket immunity, as was noted, to internet companies. In fact, those companies are liable for criminal activity and intellectual property claims, among others. But Section 230 strikes the delicate balance that encourages internet companies to facilitate speech on their platforms and take steps to moderate that speech to fit the platform's purpose without detrimental litigation. That said, there is always room for improvement. We acknowledge there are discussions happening about how to combat CSAM and health misinformation and other harmful conduct. And we want to be part of that solution, but there seems to be this perspective that if we just adjust Section 230, that will address our problem. And it's not that simple. Policymakers, we really need to think about, everyone needs to think about what problems we're trying to solve and focus on whether new regulations and obligations are the most effective means to do that. It's also important to recognize that the internet industry is very diverse. Today, this panel is focusing on concerns with social media, but each internet platform and service operates differently, sets different policies, uses different tools to make their platforms and services valuable, convenient, and safe for consumers. With such diversity on the internet, our member companies also recognize the importance of transparency and tools to help consumers, experts, and policymakers understand each platform's policies, how those policies are implemented, and provide choice and control for consumers to receive content and information. So I'll close by reiterating that content moderation at the scale and scope of today's internet is an immense challenge, but one our companies are tackling head on and are serious about continuing to improve. Now at IA, we want to be part of the conversation about solutions to concerns that policymakers have about the internet, but we need to first identify and agree upon the specific problem we're trying to solve and whether a legislative or regulatory solution is the right way to address that issue. Our member companies are working hard to build consumer trust in their services and platforms, and we're eager to engage in discussions like the one today about how our companies can continue to make the internet a relevant, convenient, and safe space for everybody. So I hope that addresses some of the points that have been made earlier. And again, really appreciate you giving us the opportunity to come here today.
No, thank you so much for being here, Matt, and for being a part of this. We want to get into details as well as the big picture. Starting at the big picture, I happened to listen to one of my favorite podcasts before this show. It's Slate's Political Gab Fest, and this was a few weeks back after the testimony by the whistleblower in the Facebook matter, and the podcast episode was titled "Is Facebook Evil?" ? Right, and so what I was struck in the discussion as I listened to it in that podcast is the tension between like one player, quite large, right? Facebook, that obviously owns Instagram, WhatsApp as well, and whether a lot of the challenges and issues about division and kind of promoting angry engagement, if you will, whether those are sort of specific to that company and that set of alleged actions, or whether kind of some of this, for lack of a better word, anger that is in our culture now is owing to the very nature of social media. Now, obviously, we've had some great discussions. Alex, your points about, hey, it's not easy to moderate. This is kind of part of the human condition. And when we've got millions of interactions because of the internet, you have problems. But I just do want to pause and ask this question about how much of these problems and challenges that are getting attention right now are owing to the behavior of one company or to social media as social media. Who would like to address that? Scott, go ahead.
Yeah, I too have heard all these revelations about Facebook in particular. And frankly, although much of what we're hearing does not surprise me about that organization, I don't think the problem is unique to Facebook. I think in part it is a social problem. The nature of our society today, and particularly on the internet, it oftentimes just comes down to Godwin's law. That's just a way.
And just remind our audience, Mike Godwin, sort of a friend of many, has a very humorous law, but please just describe it for us.
Well, it's just that on the internet, invariably, within a few minutes, somebody will end up being called a Nazi. So it is also a reflection on our society today, which is very divided in many parts. We're segregated and sliced and diced by some, and I'm not saying it's necessarily the social media companies, into these little boxes, and we're put against each other. And conflict is rampant everywhere. Everybody is always angry about everything. So, a lot of this is indeed a problem of just the way society is today, and many aspects of the internet itself. I was an internet evangelist a long time ago, and now I'm kind of sorry of what it's begotten. But let me be clear. I get the lawful but awful argument. But I also think that the problem isn't that some of these platforms, for whatever reason, allow bad actors to do bad things on their platform. It is in many instances that they are the bad actors themselves. Now, by that, I do not necessarily mean evil. I just mean bad actors. And that is because they have terms of services. And if you look at many of them, for the most part, and there are exceptions, let me just say that there are exceptions. If you look at Facebook or Twitter, for example, they promise to operate in a non-discriminatory fashion. They do set out standards, but then they promise to apply them even-handedly. And the evidence out there today is that they are simply not doing so.
Okay. Let's get other people's perspective. Again, however you want to tackle this general versus specific question, because we want to get into some more specifics just now.
Yeah, I'm happy to weigh in. I do think that the social networking sites, along with the 24/7 news cycles, have created this atmosphere that we're in today. Back in the days when I worked on the Hill in '88, you didn't have, voting for a post office was not controversial. And now every vote matters, and it creates this toxicity. And I think that the social networking platforms help increase that toxicity. Again, it's a combination of things. That's something that we try to have to solve as a society. But getting back to awful but lawful versus conduct, if you have sites that are engaged in helping facilitate illegal activity, they should be held accountable. If they're in violation of their terms of service, that should be something you should be able to go after. I think transparency of what they allow and don't allow should be very clear. And that should allow, and we should have that as part of the Section 230 discussion as well. So yes, I do think these platforms across the board, the ones that are scary, the ones we don't know about, and it's a problem and a societal problem. But it doesn't mean because we have some issues around the way platforms are engaging or people are engaging that we shouldn't try to solve the problems that we can, which is holding websites and platforms accountable. And the other thing that I would add to this is making sure that we just don't focus on the edge providers. So much discussions around Twitter and Facebook and Instagram, but we can't forget about the VeriSigns of the world, ICANN itself, GoDaddy, Namecheap, all the center and the other aspects of the internet stack that should also be held accountable when their systems and their companies and their products and they're turning a blind eye to how they're being used, and they're helping facilitate illegal activity with the selling of names or domain names or other aspects. So I think we have to look at it in a broader way.
Thank you. Good point there. It seems the fundamental dilemma from the perspective of social networks is that some people want them to moderate less and some people want them to moderate more. And they really just seem to be fundamental loggerheads. And that I don't know. I don't have a solution for that problem, because the very thing some conservatives, let's just say, want is different from the very thing liberals and progressives want. So Alex and Matt, what are some of your thoughts on this dilemma? And Shane too.
Yeah, so maybe I can just jump in quickly and just again reiterate that from our trade association, we represent a lot of different internet companies, and I can't comment on any one particular company or an individual policy that's being addressed here. But what I can say is that our companies are working hard to deliver the content and services that people want. We connect families and friends. We reach help businesses reach new customers and markets. We even find, a new restaurant or a movie recommendation, some of the simple things. We recognize there's always room for improvement, and we're eager to work with everybody, stakeholders, policymakers, to focus on specific concerns and then try to find that right balance between addressing those issues and preserving the flexibility that I think has been one of the hallmarks of the internet so far. We also agree that users should have choice and control over the content they access online, but every platform is different. Its purpose is different. Its audience is different. The tools that they use and their best are different. So one of the things we have concern about is when we're looking at obligations that make everyone do it the same way. And we're worried that that's going to undermine some of the major hallmarks of the internet, the diversity, the innovation, not to mention potentially conflicting with some of the issues on the First Amendment that I raised earlier. But we do see our companies taking steps to provide information to users, researchers, experts, policymakers about how their platforms are operating. They're getting constant feedback about that. I mean, we're all seeing it in the media of all the feedback that they're getting, and they're getting it from their users. They're getting it from experts as well. And I think they're looking for ways to enhance those efforts without undermining the security or intellectual property of their platform. So I think there's a lot of different ways to tackle some of the challenges. As Drew, as you pointed out, I think the challenges are so big that folks are pointing out that it makes it hard to try to tackle them all at once. So if we can try to drill down on the specifics of what we're trying to address, come to consensus to your point about this is the problem we're trying to solve and this is the best way to do it, I think that would really help further the conversation.
I think one of the things that has come up is the legal shield versus legal obligations and the balance. And I think Alex brought that up about the moderator's dilemma. Rick mentioned VeriSign. I worked for VeriSign for 12 years. And when I first started, they actually purchased Network Solutions. So they had every element of like the whole, like getting on the then web. This is before mobile. And what would happen is people would buy names that had any sense of traffic, or if you forgot to renew them, they would drop. And so there was this case back when Virginia Senator, well, there's been two Senators Warners, but John Warner's office called me and said, hey, AmericanTheBeautiful.org, which is dedicated to the National Park Service, has become a porn site. Do you mind going to take a look at it? Not really how I wanted to spend my day, but it made me realize that it had a lot of traffic. And so they had not paid their bill. They got into the drop pool, and in any of these kind of, I'll just call them bottom feeders, they grab these names and they pop them up. And the challenge then is what they're putting up illegal? Do I have the ability to take them down? So since the advent of mankind, these have been issues. As soon as the internet came around, the mankind issues became faster, and we have been playing legal whack-a-mole around this area, which is why I think, what you're talking about, Matt, about the terms of use and the idea of transparency and the accountability. We've seen Facebook bring the oversight board up, and the oversight board's asked some very tough questions of Facebook itself on how they are managing very specific issues. They had the pleasure of having, former President Trump be number one on their plate as they came in. But if you watch this area, you see that they have dealt with some very sophisticated, challenging legal elements and they're actually going out of their way not to just be US based, because they realize that a lot of what has come up in the Facebook files has been issues of people using the capabilities of Facebook in areas where foreign governments have kind of different regulations around this. So this is a global medium problem. I think the terms of use and the ability to, recognize these and go beyond your legal obligations, but not completely using it as a legal shield to say, I have no idea what's going on my platform, is very important. But we are definitely struggling with this as a society, not just with social media.
Can we come to this question of holding platforms accountable for their terms of service, right? What can be done in that regard, Scott?
Yeah, and I want to give one specific example, and in fact, it shows up in the Internet Association brief from Florida. Vimeo has in its express terms and conditions, they prohibit content that displays a demeaning attitude towards specific groups, including ellipses, videos that promote sexual orientation change efforts. Now, whatever anybody may think about that as a matter of policy, whether that's a good idea or a bad idea, Vimeo, to its credit, has put it in its terms of service. And so it is clear that it's not going to put up with that kind of content. And I think the platform should be able to do so. The problem is that many others do not get so specific. They take action that many people cannot understand, hiding behind very general terms that can be applied subjectively in many different ways. And one of the things that I think certainly states should be able to do is take a look at case-by-case instances where a platform has acted perhaps arbitrarily or inconsistently and affected the rights of somebody who tried to post something that was, at least on its face, allowed by the terms of service, but was then disallowed because of some strange interpretation of them. Vimeo should be able to do exactly what it did.
Okay.
The problem is
Yeah. So
Well, the other
is this a problem, right? Is there kind of, deep platforming, shadow banning of people without kind of legitimate explanation? Alex, what do you think of that?
So I guess to return to start with something I said earlier, if you look at the number of cases that come through sort of state courts or federal courts in a year, they're in like the tens of thousands. And I imagine that if I looked through some of them and I were a better law student than I had been and read more of them, I would, number one, find things that were inconsistent. And number two, I would find laws that use language in a manner that I found to be too general, or a manner that I found to be too specific. And that's because we are humans who interpret things, and we disagree over things like what is concrete enough to be good drafting practice and things like that. And I think these are areas where I think, and again, if you have essentially speech private arbitration with millions of adjudications happening per year, it is inevitable based on math that people will disagree on things such as the level of abstraction versus concreteness that is appropriate for a drafted community standard, and whether two decisions made by a company or multiple decisions made by different companies are quote unquote consistent based on one's own sort of subjective reading, and also what is context that is relevant and what is context that is irrelevant. That doesn't mean that folks shouldn't do better. And there's lots of ways in the Digital Trust and Safety Partnership, we've put out lots of points that companies we believe should agree to be held to. And some of these are due process standards that I think Scott is alluding to, such as if something is going to be removed, a user should receive notice that they've violated a particular rule and what they've done that has violated it so that they can respond substantively. And this is sort of a due process intuition that I think as Americans feels correct. I don't know that it's required, but I think it's like, I consider this a best practice to sort of port some of our intuitions around due process to the way that these private speech tribunals are working. Now, on the question of sort of like, disagreeing with the rest of the book, again, I think if you were looking at millions of speech adjudications and saying something like hate speech is bad, you can get super granular, right? You can say any speech which promulgates, supports, or endorses the efforts of these 27 groups that have been identified as hate groups by the Southern Poverty Law Center or the ADL or occasionally the US government, that will create other problems. And I promise you, you'll be back in the moderator's dilemma of having some group of people angry at you some of the time, the other time. So I think there's much to be done to like tighten up and improve and make the due process concerns and transparency concerns around these adjudications have greater legitimacy, have greater reliability. But I also think that consistency is something that we can strive towards, but I don't know if we can achieve it more in our millions of speech adjudications than we can achieve it in federal court, where I think a sampling of cases might reveal an equal level of disagreement over outcomes. I know everybody's watching a few different trials right now nationally, and I think people might say that some of the applications of evidence law and other things are inconsistent or ambiguous or happening at a level of generality that's unacceptable. And so I think this is, as I said, an aspect of being human and dealing with gigantic amounts of expression that are flowing through our pipes every day.
So two topics I'd like to get a little bit more discussion on in the remaining 6 or so minutes we've got. One is any further thoughts on the Texas and Florida statutes that Scott addressed earlier, reactions, disagreements. And the second is specifically from the Facebook files and the criticisms and the information. What next, right? What are solutions that are likely to happen either to Section 230 or to social media generally as a result of the specific issues that have been identified? Who would like to address those two topics? Either of those two topics. I want to get Matt's take on the Texas and California. So let me ask you that.
Thought you were going to come to me on that. Yeah, listen, I think as Scott noted, we have filed an amicus brief opposing the Florida legislation, and I think both that and the Texas law are being litigated, and I think you just refer to those cases and how they're going to turn out, and our arguments there. What I think is important is that we continue to advocate for policies here that enable flexibility to address all of the issues that Alex was raising, but recognizing there's room for improvement. and engaging in the right discussions about the specific issues that we need to focus on, and coming to some consensus on that. Because I think we are interested in having not just litigating these things out in court, battling them out in hearing rooms or things like that, but we're interested in having conversations to make practical changes to address some concerns that are out there. But overall, the internet industry is incredibly diverse, and while we're focusing on a few companies and the specific platforms which undoubtedly have a big impact, we have to be concerned about maintaining an environment that enables all of those companies to flourish and compete and offer new services to consumers. So I think that's where we're more focused right now, and we'll continue to engage in these issues where we need to.
Rick and Shane, what are your thoughts about those two laws, Texas and Florida?
I think there are First Amendment issues around those, and I do think that they will be overturned because of that. But my focus is more on the federal level and the changes we can get there. I just think that when you have people like Tim Mackey at UC San Diego and Eric Feinberg finding all these illegal drug sales, or Gretchen Peters in terms of antiquities that are being stolen and sold on Facebook, and you go down the list, everyone else seems to be able to find these, and they're not trillion-dollar corporations. So why is it on Facebook that everyone else seems to be able to find these things, or on TikTok, but somehow they cannot? And that's a question that has to be asked. And I think part of that gets to this duty of care, and listen to Shane's podcast with Neil Freed. If you want more details on the duty of care idea, I'm not a lawyer either. I just happen to be around these issues for 30 plus years. But I do think that there is a lack of incentive right now by platforms to do what they could be doing, because you have small entities. I think Tim Mackey's project was $1 million. Google spends more than that, I think, in a quarter of their LDAs, or lobbying disclosure activities. So they can, if Tim Mackey can do it with some scientists at UC San Diego, the thousands at Google, I think, could maybe make a bigger dent, and at Facebook as well.
Scott, quick point, if you've got one on the Texas, Florida.
I do, and I want to kind of translate it to the larger question too. I'll be very brief. The Texas bill in particular has two sections that are under attack. The first is Section 2, the second is Section 7. Section 7 is the quote censorship part. Section 2 is what I call the consumer protection part. And all that it does is basically bring these folks into a standard consumer protection, deceptive trade practices regime. It requires them to very clearly disclose their terms and conditions, and it requires them to have an internal process so that when there is a dispute, people will have a way to actually find out what the real problem is and work it through the system. I will tell you, 98% probably of the disputes that arise are probably just algorithmic things that were not due to any kind of bad actor anywhere around. It's just somebody got something taken down and they're mad about it. If we could have a far better just interaction between consumer and provider that would allow for these many disputes to be worked out internally, we wouldn't have all these lawsuits. Finally, a separate point. If we keep going in the direction that the platforms are going, where they contend that Section 230 lets them have free discretion to censor speech any way they want because of what Congress has delegated to them, you're going to run headlong into another First Amendment problem, and that's the state action problem. The folks who are lawyers might want to take a look at Lugar versus Edmondson Oil Company. That's a state action First Amendment case. It basically says that Congress can't really just delegate censorship to third parties if it gives them individual rights.
All right. We're going to give everyone a chance to offer some final thoughts, particularly on this question of solutions, specifics at the federal level. But before we do so, just want to remind everyone, next week, Wednesday at 12 noon Eastern time, we'll be talking about being thankful for better broadband with a specific focus on applications use and digital equity. We want to give a thanks to our sponsors, Utopia Fiber, Lit Communities, Broadband Money, Broadband Now, Samsung Electronics, Render Networks, Positron Access, Powerhouse Management, and the California Emerging Technology Fund. Let's go in the reverse order from the way we started. So we'll start with Matt, then Rick, Alex, Shane, and Scott, just up to a minute or less on what you see kind of the next wave of solutions, quote, reforms, changes, whether to Section 230 or to social media as a whole. Matt.
Well, as I said, I think we really need to drill down and get consensus on what is the specific problem that we're trying to solve for. And as you noted, when we've got some people saying we're not doing enough to moderate content and others saying we're doing too much, it's a real challenge to strike the right balance here. So I think the best thing from our perspective as a solution is having thoughtful conversations that need to happen here, and identify ways to address these concerns that preserve the flexibility and innovation the internet has unleashed.
Go ahead, Rick.
I think the legislation that will move forward on 230 will have a duty of care component and a transparency component. I think that addresses a lot of the issues that are concerned to the groups I work with, which is illegal activities occurring on these sites.
Thank you. Alex.
Yeah, I think we actually agree on a bunch of things. I would say things like where laws deal with transparency standards or other risk mitigation factors or due process standards, we actually agree that these are interventions where it makes sense. I would say speech regulation or anything that attempts to regulate content is a bad road to go down, and it's an itch that should not be scratched. So as laws get made, I think a lot of problems may be addressed by market diversity, the diversity of communities and places for people to interact, and the development of good risk mitigation and other practices, by professional associations. And we're sort of down that road now. So I'm hoping to meet you all in an era of more transparency, due process, and other good things soon.
Thank you for so much good substantive material there, Alex. Appreciate you joining us. Shane.
Yeah, I want to echo that, Alex. It's been great to have that context. I'm a big believer also when it comes to privacy about transparency and accountability on your terms of service / terms of use. You need to abide by what you say you're going to do. I prefer that the legal, people get away from the weasel words that they do on this, because you shouldn't be able to hide behind Section 230 for illegal activity. But I definitely see a separation between that and freedom of speech. So I don't think we solved any problems here, but we maybe have a better understanding of what the problems are.
Scott, give us your final word on this topic.
Yeah, well, I've said a lot, and I'm going to rest on that. Let me just say this. I, too, would like for Congress to act. I have no great faith that it will do so in the near future, given all the other things that are on its plate. Until it does, then pursuant to 230E3, the states have room to act and to do things so long as they are not inconsistent with 230. The arguments in all of these cases will be whether and to what extent the Texas and Florida and any other laws are indeed inconsistent with 230 or the First Amendment. And we're just going to have to fight it out in those cases.
Well, thank you. And on behalf of Scott Mccullough, Shane Tews, Alex Fierst, Rick Lane, and Matt Gerst, I'm Drew Clark with Broadband Breakfast. See you next Wednesday.